At 11:42 a.m., the courtroom was silent enough to hear paper move. The defendant had survived 6 weeks of testimony. Bank officers, forensic accountants, former employees, every one of them describing how tens of millions of dollars vanished into shell entities and offshore corridors that existed only on spreadsheets. He had remained composed through all of it, until the prosecutor said 4 words. "We'd like to play it." His attorney's hand froze halfway to his legal pad. The defendant turned slowly. Not confused, not surprised. Calculating. Because recordings had never been part of the discovery narrative presented in open court, the indictment charged him with wire fraud, securities fraud, conspiracy, and obstruction. 42 counts tied to falsified revenue statements, inflated asset valuations, and loans secured on numbers that did not exist in reality. The defense strategy had been consistent: aggressive accounting, not criminal intent; delegation, not direction; blame subordinates; attack cooperating witnesses. It was working better than most expected. Jurors had taken notes. They looked tired, not convinced. Then the prosecutor approached the evidence cart. This recording was obtained pursuant to a federal search warrant executed on March 14th, 2 years ago. It was extracted from an encrypted external drive located inside the defendant's private office safe. The courtroom shifted. The defense objected immediately. "Your Honor, we were not notified this would be introduced during rebuttal." The judge looked down at her file. "It was included in supplemental disclosure. Objection overruled." The defendant's jaw tightened. The speakers were connected. A brief hiss of feedback. Then his own voice filled the room. Clear, calm, controlled. "If the auditors ask, push the recognition date forward. They won't check the subsidiary ledger." A pause. "And move the debt into the Cayman holding account before the quarter closes." No one moved. The jurors were staring straight ahead. The recording continued. "We just needed to hold through the earnings call. After that, it doesn't matter." The prosecutor stopped the audio. "Your Honor, the government moves to admit Exhibit 312 into evidence." Admitted. The defense rose again, voice tighter now. "Context matters. That could refer to any internal accounting adjustment." The prosecutor didn't look at the defense. He looked at the jury. "Exhibit 313? A second audio file. The defendant shifted in his chair. This one was shorter. "Delete the internal memo, and make sure compliance never sees the draft." Silence again. The jurors were no longer writing. They were watching. The defense attorney leaned toward his client, whispering urgently. The defendant's breathing had changed. Faster. Shallower. Up until that moment, this had been a technical case. A battle of spreadsheets. Competing experts arguing over valuation models and reporting standards. But recordings remove abstraction. A voice eliminates ambiguity. The prosecutor approached the jury box. "Ladies and gentlemen, you have heard the defendant's own words instructing employees to manipulate reporting dates, conceal liabilities, and destroy internal documentation. This is not aggressive accounting. This is intent." The judge instructed the jury to disregard counsel's commentary and focus only on the admitted evidence. But the damage was done. The defense attempted recovery. Their forensic accounting expert was recalled to the stand. He testified that earnings calls often involve internal deadline pressure, that executives speak in shorthand, that the language used could be interpreted in multiple ways. But jurors had heard tone. Tone doesn't need interpretation. The government rested shortly after. The defense declined to call the defendant. That decision mattered. In white-collar trials, when recordings surface, testifying becomes riskier than silence. The jury began deliberations the following afternoon. 4 days. On the 4th day at 10:18 a.m., a note was sent to the judge. Verdict reached. The defendant sat upright as the jury filed in. He had not slept. That was visible. His face looked drawn, color drained. The courtroom filled quickly. Media had sensed momentum shifting after the recordings. The clerk stood. "In the matter of the United States versus the defendant..." And that is when he would collapse. Sentencing began at exactly 9 a.m. The courtroom was quieter than during the verdict. Conviction is dramatic. Sentencing is final. The probation office had calculated the advisory federal guideline range at 57 to 71 years, based on financial loss exceeding $180 million, obstruction enhancements, and leadership role adjustments. The prosecution filed for the maximum. The defense requested 12 years. The defendant entered wearing a darker suit than usual, thinner than at trial. He had aged visibly in 6 weeks. His family sat behind him. The victims were present too: retirees, investors, former employees who had lost pensions when the company collapsed. The judge reviewed the statutory factors slowly. The scale of financial harm in this case is extraordinary. She described falsified statements used to secure $240 million in loans. She described employees instructed to alter documentation. She referenced the recordings. Particularly troubling is the defendant's own voice directing concealment. The defendant stared forward, no expression. The defense asked for leniency, citing no prior criminal history and charitable contributions. The prosecutor responded with one sentence: white-collar crimes committed at this level are not victimless. They are deliberate and devastating. The judge turned to the defendant. "You may speak." He stood. His voice was lower than at trial. "I never intended to harm anyone. I relied on my team. I regret how this unfolded." No apology. No acknowledgement of falsified records. He sat down. The judge folded her hands. "The evidence at trial established that you personally directed fraudulent reporting and concealment. The harm was widespread. The need for deterrence is significant." She paused. "For counts 1 through 42, this court imposes a sentence of 60 years in federal custody." There was no gasp, just silence. 60 years. Effectively life. The judge continued. "Restitution will be ordered in the amount of $183 million. You are remanded to custody immediately." That was when it happened. He blinked once, twice. His mouth opened slightly. His shoulders stiffened. For a moment, he remained standing. Then his body locked, rigid. His attorney reached toward him. Too late. His knees gave way. He fell straight down, striking the polished floor hard. The sound echoed. The courtroom erupted in controlled movement. Marshals stepping forward, defense counsel kneeling, someone calling for medical assistance. The judge remained seated, but ordered the courtroom cleared. The defendant lay motionless for several seconds. A marshal checked his pulse. "He's breathing." Paramedics arrived within minutes. They identified it as acute stress-induced syncope. His blood pressure had spiked and then crashed. He had fainted. He regained partial consciousness as they lifted him onto the stretcher. 60? He whispered. No one answered, because everyone had heard it. 60 years. In federal custody, that means serving at least 85%. He was 58 years old. The math was unforgiving. As he was wheeled out, one of the victims in the gallery remained seated, not smiling, not satisfied, just watching. The judge reconvened briefly for the record. The sentence stands. The defendant was present when it was imposed. That matters legally. Presence. Consciousness is not required, only presence. Outside the courthouse, cameras waited. Inside, the courtroom returned to stillness. The hidden recording had started it. A voice captured 2 years earlier inside a private office safe. Without it, this might have been a civil dispute. With it, it became a criminal conviction. And with that conviction came 60 years. The system did not collapse. He did. If you want analysis of the appeal strategy and whether a sentence this severe could be reduced, tell me and I'll break down the legal pathways next.